Welcome to Law Sessions. I am Jennifer Housen. In this session, I will introduce you to 1, the basic concept of what a contract is, and 2, an introduction to contract formation. In particular, we will focus on the principles of offer and invitation to treat. Now, offer and acceptance together is termed agreement, but our focus in this lecture will be an introduction to contract and the concept of offer, and then contrasting it to the principle of invitation to treat. Now first, starting with the basic concept of what a contract is. The layperson would of course say that it is an agreement between 2 or more persons, but that is what will distinguish you, the budding lawyer, from the layperson, because throughout this series you will hear me tell you to go to source. Now, in studying this or any other topic, never ever rely solely on what a tutor says, or a lecturer says, or God forbid, what a fellow student says, or even what I may say to you. Check for yourself from source, which for you as the law student, of course, means the experts. And by the experts, I mean the academics and the court decisions. Yes, you must read the cases. And if legislation is involved, what a particular act says. Now it means that whatever we discuss here, we will go to source. Now then, what is a suitable definition of a contract? Well, if we were to go to the source for the answer, the first response, in my view, is from Professor Tritle, who says that a contract is an agreement giving rise to obligations which are enforced or recognized by law. Now, he carries on by saying that the factor which distinguishes contractual from other legal obligations, for example, tort, is that they are based on the agreement of the contracting parties. Now, Sir Frederick Pollock, for his part, says that a contract is a promise or a set of promises which the law will enforce. And of course, not to be outdone, we see Sir William Anson saying that the law of contract may be provisionally described as that branch of the law which determines the circumstances in which a promise shall be legally binding on the person making it. So as a starting point, therefore, we can see that the great minds of contract law are united, not least that in the law of contract, not all agreements will be an agreement that is enforceable in law. So if we are dealing with a social arrangement, for example, say I ask my son to wash my car, or if we are dealing with an illegal agreement, so you and I agree that you will use my spare bedroom for the purposes of prostitution, or if we're dealing with an agreement that is contrary to public policy, so making an agreement which the law disapproves of, then such agreements, unfortunately, as much as I would like the income from the proceeds of the spare bedroom, will not be enforceable. It is the enforceability requirement which is significant in determining what is a contract. Now, the 3 essential elements of a valid contract under English law are agreement, meaning offer and acceptance, intention to create legal relations, and of course consideration. Now, by the end of this session, we will have reviewed the contract element of agreement, which is usually expressed in terms of offer and acceptance. It is that meeting of the minds of those 2 parties, the consensus ad idem, that meeting of the offer with the corresponding acceptance that constitutes the agreement. So our objective over this session are to know what is an offer and to be able to distinguish an offer from other forms of communication. In particular, what is an invitation to treat? So we will know what is the correlation between offer and possibly acceptance, and then what is meant by an offer. And of course, consider it in the context of invitation to treat. Well, an offer could be defined as a proposal or a promise by one person, who is called the offeror in law, to enter into a contract on a particular set of terms with the specific intention of being bound by that promise, as soon as the person to whom the promise is made, called the offeree, signifies his acceptance. Now, that may sound a fairly long definition, so let's put it another way. It is where, from an objective standpoint, there is an expression of willingness by the offeror to be bound by its terms once it is accepted by the offeree. Now then, an offer may be made to an individual. It may be made to a group. It may be made to the general public. So, for example, a reward for information or a reward for finding and returning a dog. An offer may be written. It may be spoken. It may be implied by conduct. Now, one important point for law students to remember is that what in fact amounts to an offer can and certainly does give rise to differences of opinion. So, for example, during the bargaining process, there may be a series of communications between the offeror on the one hand and the offeree on the other as they move towards a final agreement. And so it may be difficult to be exactly sure whether a specific statement was an offer or whether it was only part of continuing negotiations between the parties. It is these that you have to be careful of, because examiners tend to seize on and exploit these when they are writing contract law questions. They want you to discuss the fine line distinctions by using the cases and going to source for academic commentary in determining if a particular communication is an offer or not. Now, one possible approach in determining whether there is an offer is to examine whether they were expected to bargain further. Were the parties expected to bargain further? Or whether the communications made to that point showed a clear willingness to be bound if the other party agreed or assented. Now, this is easier said than done, as the cases conflict at times. In fact, to understand the principle of offer, any discussion must consider the two contrasting cases of Storer and Manchester City Council in 1974 and Gibson and Manchester City Council in 1979. Now, both cases were concerned with Manchester City Council's policy of selling off council houses to its tenants who were living in them. Now, councils in England tend to be the largest social landlords, and in a particular area and at any time, Manchester City Council was controlled by the Conservative Party, and this was an era when there was a Conservative Party policy to make homeowners of their council tenants. So basically, persons who had been renting their properties now had the right to buy them. And this was considered the right to buy scheme, making people owners of their own property. Now, Mr. Storer and Mr. Gibson were two such tenants who wanted to buy their council house. However, control of Manchester City Council passed to the Labour Party, who of course took a more paternalistic view of selling off housing stock of the council. And they resolved to discontinue the sale of council houses. And what we will discuss next is how the council's communication to each of the two gentlemen was viewed by the court and the determination by the courts of the status of each communication. By way of recap, therefore, Tritle, Pollock, and Anson say that a contract is a legally enforceable agreement. The requirements of a contract are agreement, meaning offer and acceptance, intention to create legal relations, and consideration. An offer is an expression of willingness by the offeror to be bound once there is acceptance by the offeree. We will then go into part 2, of course, and we will continue with offer as well as the 2 cases raised earlier, and in that segment we will look at the contrasting cases of Storer and Gibson and further consider the situations where an offer is shown as being distinct from an invitation to treat.